is Kwaku Darfour. I'm an attorney here at the Darfour Law Firm here in Fort Lauderdale, where our main office is located. We practice personal injury throughout the state of Florida. Thank you for joining me. Today, I'm going to be talking about truck accidents and some common defenses to causation in truck accidents, right? Truck accidents are usually very severe, and there are some defenses that you can expect the attorney handling the case for the driver of the truck or the company that owns the truck to bring up. Some of those most common defenses are contributory negligence, and I'll explain to you what that means, give you an example as well. But contributory negligence, in Florida now, you have what they deem as comparative fault, and that happens if you're more than 50% at fault for the accident, then you can't recover anything. Before, you could recover a percentage of what you weren't at fault for of your damages, right? So you have contributory negligence, you have assumption of risk, right? You have no causation at all, right? Like there's no causation, between what happened and your injuries, right? There was something else that caused it. You have prior existing injury as well. So those are just four, right? So let's start with what contributory negligence is. In a contributory negligence scenario, they're going to argue that you did something that also contributed to your injuries, whether you didn't have your seatbelt on, maybe you swerved and somehow, or collided with the truck and should have avoided the truck. Maybe you slammed on your brakes, or maybe you didn't speed up. There's going to be something that they add that says that because you didn't do that act, or because you didn't act, you added to causing the accident, right? And so you were part of the cause of your injuries. Plaintiff's attorneys are going to strongly argue against any contributory negligence at all. If there is, we're going to argue that it's the least, the jury should find for the very least amount, and it's de minimis, right? It's very little. Another common defense that you may hear is that of assumption of risk. Like for some reason or somehow you assume the risk by driving too close, let's say, to a truck, that you basically allowed that risk to potentially cause you an injury by driving so close. So you assume that risk by driving too close, or maybe by braking in a certain fashion right in front, or maybe speeding up right in front of a truck or something like that, or changing lanes right in front of a truck or something like that. Those are some examples there, right? Some of assumption of risk. You have no causation at all, right? So you may have a situation where there's an intervening cause, right? Something happened after the defendant's negligence that superseded, their action, and that was the legal cause. That's what caused your injury. So though the defendant did commit negligence, their negligence was broken in terms of a chain of events, and somebody else's negligence was the cause of your injury, right? So those are that's another an example may be, where somebody runs a red light, but they swerve, and you at the same time get hit because you ran a red light and smashed into something, and that smashing into something and you running the light after someone else ran the red light, way ahead of you, cause your injuries. Maybe not the best example there, but you get the point there about the intervening and superseding cause. Some defense attorneys will try the most creative theories of defenses, right? So you have to make sure that you have a very credible, intelligent, well-spoken, confident, a great communicator when you're choosing your expert witnesses, okay? You want your experts to be able to debunk the narratives that the defense attorney is going to put forward, in that somehow you are not as injured, or somehow you contributed to as the cause of your accident. And what you want to do is, your attorney wants to make sure that when they go into court, into trial on your case, they obviously pick a good jury, but they also want to make sure that they address these potential defenses that are going to be coming up, right? And address them in a way where they refute them early on. You don't want it to be lingering in the mind of the jury, you want to address it and then refute why those can't be actual defenses, right? Or why they should be very limited, okay? So those are some of the reasons, and some of the strategies that you can use are, sometimes making just analogies and comparisons so that you can bring it to life to something that the jury may connect with and understand easier, right? So that's all we have today for some of the common defenses to causation in truck accidents. As always, thank you for watching. If you think that you learned something, or you think that this video provides you value, go ahead and hit the subscribe button down below. Go ahead, right down. That way you can get alerted of any future videos that we put out. And then also, if you think you have a case that maybe we can represent you with, go ahead and give us a call at the office here, or go ahead and email us, and we will review your case for free, no charge to you, and let you know if we think that we can represent you in that case.